Good morning, friends. What is comprehensive? Comprehensive means
Good morning, sir.
Good morning, sir.
Morning, sir.
morning. Ready with the constitutional debates?
To debate on, there are 12 volumes on constitutional debates. What I have seen in the reports. Am I right, sir?
Huh? What?
Sir, there are 12 volumes on the Constitutional Assembly debates, sir. Am I right?
Yeah, we have listed out certain constitutional debates, topics, on the topics, the discussion. So, what are the topics at least? You have written, no?
Untouchability, Uniform Civil Code, Reservation, Preamble, Abolition of Death Penalty.
Abolition of
Death
Death
penalty.
penalty.
Death penalty.
So start with any one debate.
Next thing is, there are three main things. They are broken down again. First is
So you take
Untouchability.
almost 3 days. Huh?
Sir, I will start with untouchability, sir.
Untouchability
Yeah.
of constitutional debates.
Yes, sir.
Okay, start.
Is the practice of outstretching a group of people regarded as untouchable, as ascribed by the secondary. Now, according to Hindu literature, the Manusmriti literature, to persons of high caste or to persons excluded from the caste system, resulting in segregation or persecution from the people regarded. That is about untouchability. I mean,
I think Mr. Srinivas is active, others are not so active. I don't know.
That's it.
Okay, what's the name of matter of the
No.
Sir, this is about untouchability only, sir. Actually, what is the debate happened on 29th of November 1948. I'm going to speak, sir. The Constituent Assembly debated on draft Article 11 on 29th November 1948. It was about the removal of untouchability. So, untouchability on the basis of religion or caste was intended to be abolished by the Constitution framer. Mr. Naziruddin Ahmad proposed the amendment: no one should be treated or regarded as an untouchable because of his or her religion or caste. So Muniswamy, Mr. Muniswamy Pillai also told about untouchability, that it should be abolished. Also, Mr. Mono Mohandas also told it is an important fundamental right. There must be protection from humiliation and dishonor and be made a criminal offense under the Constitution. The same way, Mr. Shantanu Kumar Das, Professor K.T. Shah, everybody debated on the issue, untouchability. So it was already there in the Article 11. So the different things in the debate, it was also proposed an amendment to clarify the definition of the term untouchable. What is it? So to make it explicitly applicable to caste and religious untouchability. So one more thing, like it is the that there should not be any discrimination for the people, and so there should not be any discrimination in public workshops and religion, race, and all. I told, no, sir, already, and it should not be there to and access to the shops, public restaurants, hotels, and places of public entertainment. Everything was included in that article, and So something it has been misplaced, sir. Like this is the thing about the untouchability. It was in the Article 11. Later, it has been changed to Article 17, sir. So this in 17 also some in draft article, and it was adopted. The draft article was adopted on 29th November 1948. This Article 17 of the Indian Constitution abolishes the practice of untouchability finally. So it has been come into force on 1st June 1955. And also this act, the Untouchability Act 1955, makes this practice punishable offence. It has been fined also that 6 months imprisonment or fine of rupees 500. Oh, that's all, sir. I could connect it.
Okay, great. Next. Yeah, Parvati Prasad, start.
Constitutional Assembly Draft Article 11 stated on 29th November 1948, sir. Draft article was about to removal of untouchability. As per Nazaruddin Ahmad, Article 11 article is substituted. He moved the above amendment because the word untouchability has a legal meaning and it is not applied for human beings, but it is applied for the variety of things. Amendment was negative because the framers were not interested in substituting the above aspects, sir. As per the Mono Mohan Das, any sort of special privileges must not be given to the minority communities. Practice of untouchable to be made a punishable crime under the Constitution. The words of Mahatma Gandhi, he said he want to be reborn as a Harijan so that I may lead continuous struggle against the oppressions that heaped upon this class of people. He further addressed that the word Swaraj become no meaning as untouchability is not abolished. So there is no word like untouchability in the Constitution. So we must follow and respect the Constitution and prohibit on the grounds of the religion or caste, sir. That's all, sir. Thank you.
Okay, thanks, sir. Next. Next. Ready?
Sir, myself, Sylvan Rachi.
Yeah, start Vinay.
Hello. Sir, I'm going to talk about the debate on abolition of death penalty. Mr. Sorry, sir.
Start, Charles.
Yeah. Mr. Z.H. Larry advocated the introduction of Article 11B during the Constituent Assembly deliberations, in which he proposed the removal of capital punishment save for sedition involving the issue of violence. According to him, capital punishment has been banned in a number of countries around the world. He made his argument because after the sentence is proclaimed, the perpetrator is no longer living. If the court or tribunal later discovers that it made a mistake, that is, that the individual on whom the sentence is imposed is not guilty, the mistake will be irreversible. He was a firm believer in the sanctity of human life. Only when a man's life is in jeopardy to the lives of others in society can his life be taken. He cited 30 countries around the world where society as a whole is protected without such punishment. He also admitted that capital punishment is inherently barbaric and that such feelings no longer exist in the 21st century. He used the examples of Charles Dickinson, who remarked many decades ago that capital punishment motivates those who are determined to commit murders to conduct murders because it is accompanied by a sense of martyrdom. He then stated that capital penalty is appropriate for chronic murders, but that life imprisonment is appropriate instead of capital punishment for murderers who have committed the crime only on rare occasions. He then proposed that the punishment have a reformative component. He demanded that in the case of punishment, reformation be given first priority. He called for the death penalty to be abolished on three grounds. One is human judgment, the sanctity of human life, and the purpose of punishment. He also agreed that if the state is put in jeopardy and there is a possibility of many people losing their lives, such punishment may be imposed. He also predicted that the punishment would be abolished permanently by the parliament in 2 or 3 years. That's it from my side, sir.
Okay, thank you. Next. Next. Uniform Civil Code. Okay, right? Start.
Sir, Uniform Civil Code is one that would provide for one law for entire country applicable to all religious communities in their personal matters such as marriage, divorce, inheritance, adoption, etc. It comes under Article 44 of the Constitution lays down. Article 44 is one of the directive principles of state policy. The status of uniform codes in India is like do follow a uniform code in the most civil matters such as Indian Contract Act 1872, Civil Procedure Code, Transfer of Property Act 1882, Partnership Act 1932, Evidence Act 1872. Recently, several states refused to govern the Uniform Motor Act 2019. The background of Uniform Civil Code is it comes to colonial India when the British government submitted its reports in 1835, stressing the need for uniformity in the codification of Indian law relating to crimes, evidence, and contracts, specifically recommending that personal law of Hindus and Muslims be kept outside such condition. And one more important, the background is increase in legislation dealing with personal issues. The far end of British rule forced the government to form a B.N. Rao committee to codify Hindu law in 1942. And there are two case laws. What I have seen it is the judgment in the Shano Bano case in 1985 is well known. And one more another case is Sarla Mudgal case in 1995, which dealt with the issue of bigamy and conflict between the personal laws existing on the matters of marriage. And one more argue is that practice of such triple talaq and polygamy act is also included for this Uniform Civil Code. There are some implications about Uniform Civil Code. There are important implications. What I have seen is protection of vulnerable sections of society. Second one is simplification of law. Third is adhering to ideal of secularism. Fourth one is gender justice. And there are some challenges for Uniform Civil Code. There are some expectations as well as communicable policies and constitutional hurdle. So these are comes under Article 25 and Article 14. What I have seen, sir. That's it.
Okay, good. Next. Yeah, your good name? Jyotsna.
Jyotsna, sir.
Yeah, start.
Constituent Assembly in India for first time met on 9th December 1946, sir, and took 3 years to frame the world's largest constitution, the Indian Constitution. The members of the Assembly were indirectly elected by the members of the provisional assemblies that existed during the British Raj. The drafting of the Constitution was not an easy task. It took months and years of debates and discussions to arrive at the final draft of the Constitution, and then Constitution was enacted on January 26, 1950. Among all the debates that took place in the Assembly, the debate on reservation was among the most prominent ones. When Britishers left India, the country was shattered into pieces, and it was need of time to bring all pieces together in order to run the country. When the Assembly met for framing the Constitution, all classes of society were addressed, be the upper class Hindus or lower caste. And since fact the class and the caste discrimination are deeply rooted in India cannot be denied, policies such as reservation had to include to achieve the principles of democracy. Need for reservation, sir. India is a vast country with different cultural and religious backgrounds with a population of almost 134 crores. It becomes important to ensure interests of all and to safeguard the rights of the socially and educationally backward classes, to assimilate all sections of the society into national mainstream. The issue of reservation was raised by the Dr. B.R. Ambedkar in the assembly, sir.
That's it.
Sir, it's there, sir. The issue of reservation has not solved even today in India. The parliament and the whole nation is still working on it. Some are actually receiving its benefits while some are suffering. Though the suffering is because of lack of checks and balances. The parameters that were decided back then cannot work in the present era. The policy needs to amend it with time and by keeping in mind the current needs. Cash-based reservation might not be a solution now. The economy-based reservation has to find wider dimensions, and then only India would be able to achieve the constitutional principles of equality and non-discrimination. Thank you, sir.
Yeah, thank you. Next. Next.
Sir, can you tell again about preamble? Yeah, you can tell Tiwari.
Yeah, Prasad.
Sir, constitutional debate on federalism, sir.
Okay.
N. Gopalaswamy Iyengar, sir, proclaimed that principles of federal constitution is must provide method of dividing powers between center and state. And the President Ambedkar clearly stated that the President can exercise powers under Article 250, 352 and 350 of the Constitution to exercise the and this exercise requires the approval of both houses of Parliament. According to Article 1 of Constitution, India is a union of states. As chairman of drafting committee, Ambedkar was responsible for the word union being substituted for the federation. The drafting committee stated that the advantages of describing India as a union despite of constitution being federal is structure. Thank you, sir.
Next. Kranti, you are about to say something?
Sir, can I say something about preamble debate?
Okay, start.
We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and get to ourselves the Constitution. The importance of the debate summary on preamble is the Constituent Assembly debated the preamble on 17th October 1949. The debates around the preamble revolved around the name of India and inclusion of God and Gandhi. One member urged the Assembly to rename India as the Union of India Socialist Republic, similar to the USSR, which is nothing but now Russia. Members were not convinced with the suggestion as they felt that it would go against the already adopted constitutional scheme. Another member sought to include in the name of God. Many were opposed to this suggestion. It was noted that it was unfortunate to put God on vote. One member believed that inclusion of God would amount to compulsion of faith and violate the fundamental right to freedom of faith. Another proposal was made to include Gandhi's name in the preamble. A member was discontented with the already adopted draft articles as he felt that Indian Constitution was based on the American Supreme Court cases and Government of India Act. He opposed any association of Gandhi with the rotten Constitution. The amendments moved by the members were negatived. However, this was one of the rare instances of assembly proceedings wherein the members voted on the proposal to include God by a show of hands. The assembly was divided with 41 voting in the favor and 68 voting against it. The assembly adopted the preamble as presented by the drafting committee. That's it, sir. Thank you. Thanks all.
Okay, thank you, Kranti. Next. Start.
As per the Indian Constitution, the nation follows threefold distribution of legislative powers between union and state government, sir. As per J.B. Kripalani, who was the president at the historic minute session 1946 of Indian National Congress, while outlining the proposal constitution, stated that it must be federal in character with maximum autonomy given to the states. Dr. Ambedkar presented the draft constitution to the Constitutional Assembly. He described that the constitution proposed to be federal, even though the word used in Article 1 was union and the word federal was never mentioned in the preamble, sir. In view of the external condition as well as the vastness of the country, unitary system is not only undesirable but also unworkable. India therefore was going to have a federal constitution. This was carried till end. After the partition, the necessity of a strong center was imperative, and going back to unitary system was not option, sir. As per Gopalaswamy Iyengar, as per his views of the essentials of federalism constitution is that it must be provide for a method of dividing sovereign powers so that the government of the center and government at units are each within a definite sphere, coordinate and independent. He said orthodox definition of federalism adopted by other constitution was not rigidly followed. He said definition would not apply to Indian context as they were facing many problems. The problems was integrate and bring areas which were under the British crown under federalism. As Dr. Ambedkar, he made it clear and President can exercise the power under Article 250, 352 and 353 and request the approval of both the houses. He opined that the constitution make both a unitary as well as a federal normal times, federal in times of war, unitary system. He clarified that though India was to be a federation, but not mere agreement or contact, it was union because it was indissoluble. India will be prosper only if it all states prosper. If there is a difference between the states in the center, the foundation of the federalism and democracy will start collapsing. That's all, sir. Thank you, sir.
Okay, thank you. Next. On?
Federalism, sir.
Okay, start.
Federalism in India refers to relationship between the central government and state governments of India. Part 9th of the Indian Constitution specified the distribution of legislative, administrative and executive powers between the Union government and the states of India. As India, a developing nation, federal government is necessary for it to bring progress. India is country with unity in diversity and also constitutional laws of India suit the federal governance. India requires federal ruling to maintain national integration. Thank you, sir.
Thank you. Next. We are seeing almost 41 people. At least by seeing, they have to respond, no?
Yes, sir, myself Kiran. This is a debate summary for Uniform Civil Code. The state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. The Constituent Assembly took up draft Article 35 for debate on 23rd November 1948. As the text of the draft article suggests, it directed the state to bring out the uniform civil code across India. The debate around the draft article triggered conflict. Most of the opposition to the draft article came from Muslim members who moved amendments to keep personal laws out of draft articles scope and introduce a proviso that operationalized the draft article only with the prior assent of the community. The arguments mobilized to attack the draft article included first, that Uniform Civil Code violated freedom of religion. Second, the draft article would create disharmony within the Muslim community. And the third, it was wrong to interface with personal law without the approval of religional communities. The draft of article did find support. Members argued that the Uniform Civil Code was important to uphold the unity of the country and the constitution secular credentials. One member reminded Muslims member that this was not an opinion that would affect the Muslim community alone. Even the Hindu community had to deal with it. It was further added that women's right cover never be secured under this. Also, the argument that Uniform Civil Code would violate religious freedom under the Constitution was rejected. The Constitution gave the space for social reform legislation. At the end of the debate, it was declared that there was nothing new about the Uniform Civil Code. There was already a common civil code in India. The only difference with the new was that it would cover marriage and inheritance, which were not under the scope of the existing code. It was also pointed out that the Uniform Civil Code was a directive principle. 1 minute, sir. Principle, the state was not obliged to bring the provision into the effect immediately, and there was space for the consent of communities to be obtained. That's all, sir. Thank you, sir.
Thank you. Next. Next. Just by saying, you people have to respond, no?
Not asking directed debate.
Sir, I would like to tell about Constitution Assembly debate on reservation, sir.
Okay, Sachin, start.
The Constitution Assembly in India for first time met on 9 December 1946 and took 3 years to frame the world's largest constitution. The Indian Constitution, the members of the Assembly were indirectly elected by the members of the provisional assemblies that existed during the British Raj. The drafting of the Constitution was not an easy task. It took months and years of debates and discussion to arrive at the final draft of the Constitution, and then the Constitution was enacted on January 26, 1950. Among all the debates that took place in the Assembly, the debate on reservation was among the most prominent ones. When Britishers left India, the country was shattered into pieces, and it was the need of the time to bring all the pieces together in order to turn the country. When Assembly met for the framing of the Constitution, all classes of the society were addressed, be it the upper class Hindus or the lower caste. And since the fact that class and caste discrimination are deeply rooted in India cannot be denied, policies such as reservation had to be included to achieve the principles of democracy. Need for reservation. India is a vast country with different cultural and religious backgrounds, with a population of 134 crores. Becomes important to ensure the interest of all and to safeguard the rights of the society and educationally backward classes, to assimilate all the sections of the society into the national mainstream. The issue of reservation was raised by Dr. B.R. Ambedkar in the assembly. There are certain classes who have not been given adequate opportunities in the past due to rigid hierarchies and monopolistic government of the time. But a constitution is being framed for a democratic country, then all the sections of the society should get represented, and special provisions should be made for the unimplementation of those at the bottom. They should be given their chances to overcome the difficulties that exist in their lives, and for this government has to work on the principle of equity, and which means providing proportional equality, the protection of minorities against the interest of the majority was one of the fundamental concerns behind the reservation policy. This led to a serious discussion in the assembly, followed by the conflicting interprets of people. Thank you, sir.
Thank you, Sachin. Next.
Sir, I would like to read through the debate on abolition of death penalty.
Okay, right. Start.
This is Feroz. So, Constituent Assembly debate on abolition of death penalty. Between 1947 and 1949, the Constituent Assembly debated on the death penalty. The question was asked because of its judge-centric nature, possible uncertainty in its enforcement, its discriminatory impact on the poor and the marginalized sections, and the possibility of error in the final judgment. During the debates in the Constituent Assembly, Mr. Z.H. Larry proposed for the insertion of Article 11B, in which he proposed the abolition of capital punishment except for sedition involving the use of violence. He stated that capital punishment is abolished in various countries of the world. He proposed so because once the said punishment is pronounced, the offender remains no more alive. Later on, if the court or tribunal comes to know that it had committed a mistake, that is, the person on whom such sentence is pronounced is not guilty, then such a mistake cannot be rectified. He was of the opinion that human life is sacred. The life of a man can be taken only when such a man is harmful to the lives of others in society. He gave examples of 30 countries of the world where society is protected at large without such punishment. He also admitted that capital punishment is brutal in nature and sentiments of brutality do not prevail in the present century. He quoted the example of Dickens that many decades ago, Dickens stated that capital punishment encourages that section of population which is determined on committing murders to commit murders because that is accompanied by a sort of martyrdom. He then proposed that for habitual murderers, capital punishment is proper, but for those murderers that have committed the crime occasionally, for them life imprisonment is proper instead of capital punishment. He then proposed the introduction of a reformative element in the punishment. He demanded to give prime consideration to reformation in punishment. He demanded the abolition of capital punishment under 3 grounds: visually, human judgment, the sanctity of human life, and the purpose of punishment. He also admitted that if there exists a situation in which the state is put into danger and where there is a risk of loss of life of many people, then such punishment may be inflicted. He also expected the parliament to abolish the said punishment permanently with 2 or 3 years. Within 2 or 3 years. Thank you, sir.
Thank you, Firoz. Next.
Will not direct the SSC.
Sir, good morning, sir. Surya. Preamble, sir, about the preamble and components of preamble. It is indicated by the preamble that the source of authority of the constitution lies with the people of India. Preamble declares that India to be sovereign, socialistic, secular and democratic republic. The objectives stated by the preamble are to be secure, justice, liberty, equality to all citizens, and promote fraternity to maintain unity and integrity to the nation. The date is mentioned in the preamble, sir, when it is adopted in the November 26, 1949. So some keywords are there in the preamble. We, the people of India, it indicates the ultimate sovereignty of the people of India. Sovereignty means that independent authority of the state not being subject to the control of any other state or external power. Whereas the sovereign means that all India has its own independent authority and it not dominion of any other external power. In the country, the legislature has the power to make laws which are subject to certain limitations. Whereas that in socialistic, sir, means that achievement of socialistic and through democratic means it holds faith in a mixed economy where both private as well as the public sector. It was amended by the 42 amendment in 1976. Secular, that all religions in India get equal respect, protection and support from the state. So whereas that in the democratic, it implies that the Constitution of India has established form of constitution which gets authority from the will of the power expressed in any election. And republic, the term indicates that the head of the state is elected by the people in India. The president of India is elected head by the states. So these all are the key words in the preamble, sir. Thank you.
Yeah, thank you. Next.
And only such assistance after hearing from the SSC issues, all these SSC.
Very good participation by the students. Trying to make some more debates. And moreover, we are starting today Parliament budget sessions, isn't it?
It shall be granted to the SSC.
Are you aware about it?
So, the acknowledgement of the written shall be
Hope it is from second.
section.
Huh?
Is it from today or day after tomorrow?
From today.
Okay.
Tomorrow budget.
Yes, sir.
So today the President of India is addressing the both houses of Parliament. The system of Indian Parliament that the starting session of a year addressed by the President. Okay. So try to go through that presidential address of both houses of Parliament of today and make the points of your interest or complete the budget session and make the summary of the session, the presidential address. And who prepared this session, this speech? addressing speech by the president. Who will prepare and the important points of the presidential address of today? Okay, hope you will get tomorrow.
Okay, sir.
By tomorrow class.
Sir, one question.
Yeah.
These budget sessions happens every year in India. So these are also part of the constitution law?
Yes.
In general. Okay.
Yeah, budget, this parliamentary system is in the constitution, no?
Okay.
Okay?
All right, sir. Thank you.
Okay. Any doubts?
No, sir.
So you'll get the presidential address summary and who will prepare, who will draft the speech, all that. Okay, tomorrow class, okay?
Thank you, sir.
Thank you.
Sir, one thing, sir.
Yeah. Yes.
I would like to know whether when we are studying law, is it necessary to know about politics?
Is it?
Is it necessary to know about the running politics in the country?
Politics, sir?
Right, sir.
Yes.
Okay. Means is that important to know about the politics? That is my question, sir.
That is your interest. Some people will have the more important, some people will have the less important, some people will have the middle.
Yes,
But
sir.
knowing the politics is important. Knowing the politics is important. How you explore the politics is different.
Okay. No, whether it is related to law or like that, my intention.
Each and everything can relate to the law. How you will relate is depends upon your study and your research.
Okay.
So name any category which are not related to law.
Yeah, sir. Like few
Any one
people do
category?
not have any interest in politics. So those people what to do?
Yeah, try to make one more assignment to knowing the better law. Name or listed some areas where you cannot relate to the law.
Where you cannot relate the law. Okay.
And 10 points. 10 points where you can relate to the law.
Okay.
First, you have to link or relate or connect with the law. How you will connect? 10 points of your area. And your choice. Either you can write 5 or 10 where you cannot connect, relate to the law. Okay?
Actually,
Sorry?
politicians are called as lawmakers. Maybe that is why we need to know politics also.
Yeah. So each and every individual is a politician. If your individual capacity, either in your family or your profession, you will also do a politics, isn't it?
Right.
Yes, sir.
Then, if only we are interested on the politics, where we can see by the politicians. So what is the politics?
Yes, what day to day what we are doing, that only.
That is. Okay.
Right, sir.
Yeah. Thank you, sir.
Tomorrow assignments are
Today's president's speech.
next.
It's not a president.
The politics are relating to the law. How you can relate? Make it 10 points. And the next points, sir, we cannot relate these subjects or these areas to the law. Those we can discuss tomorrow. Which you are listed is okay. Sir, this point is listed. This point is listed and connected to the law. Okay, you can justify that.
So tomorrow, is it continuing the online class or college study?
You will receive a message. Okay?
Okay, sir. Thank you.
Either it is online or offline, you will have a class.
Because there is also scope for summary assessment.
Okay?
So short course, you will get this summary assessment.
Thank you.
Sure, sir. Thank you.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.